हाय फ्रेंड, नमस्कार। मैं विपुल कंपनी लॉ वीडियो सीरीज में आपका स्वागत करता हूं। आज हम लोग देखेंगे हाउ टू कंपाउंड ऑफेंसेस अंडर द कंपनीज एक्ट 2013। फर्स्ट वी नो व्हाट इज द कंपाउंडिंग, what are the advantages of the compounding of the offenses under the companies act, what are the types of the offenses which are compoundable or which are not compoundable, what are the procedure involved in the compounding of the offenses, and what is the effect if failure to complying with the compounding order, and difference between the adjudication and compounding of the offense. Let's start the presentation. Under Companies Act Chapter 28, Section 441 provide provision for the compounding of the certain offenses. Compounding is the settlement mechanism under which party in default or offender pays some prescribed amount of the money to the competent authority in lieu of getting prosecuted. Advantage of the compounding, that is it is the summary proceeding. When you go to court, this is the lengthy process and it is the summary proceeding and less time consuming compared to the education, prosecution and in court, and it does not burden court with the cases and act as a deterrent and prevent commission of the offenses. That is the advantage of the compounding of offenses. Compounding of the offenses under section 441 of the Companies Act. Compoundable offense is made good by paying fee as decided by the competent authority, that is the NCLT or regional director, as per the threshold limit. The fee so paid is not a penalty and cannot act as a ground for disqualification of director. The fine so charged cannot be more than the amount prescribed by the relevant legal provision. Any offense punishable under the Companies Act committed by the company or any official may be compoundable by tribunal or regional director, where a maximum amount of the fine imposed for such offense does not exceed 25 lakhs. Then regional director is the competent authority, otherwise tribunal is the competent authority. And types of the offenses, this is the compoundable. So compoundable offenses, that is offenses that are punishable with fine only. And second, offenses that are the punishable with fine or imprisonment. The fine या imprisonment और दूसरा fine only, that case offenses are compoundable. Non-compoundable offenses, when we analyze this thing, then the offenses which are punishable with imprisonment only, that is the non-compoundable offense, and where punishable with the imprisonment and fine, that is the also non-compoundable offense, because compoundable offenses is the punishable with fine only or imprisonment or fine. In that case, you go for the compounding. Offenses cannot be compounded in case a similar offense committed has been compounded and period of the 3 years has not expired. In that case, if period is not expired or 3 years not expired, in that case, that offense is the non-compoundable offense. And offenses cannot be compounded in case either the investigation has been initiated or is pending. As per section 441 subsection 1, that is the non-compatible. Any subsequent offense committed after expiry of the 3 years from the date of the compounding shall be deemed to be the first offense. Now, Let's see the procedure involved in the compounding of offenses. Convene a board meeting, determine offense and calculate fine paid by the company or officer default as per the relevant section, and pass the resolution to file an application for compounding of offense. Authorize director or any officer of the company to sign and submit the application on behalf of the company, and appoint professional lawyer, company secretary, chartered accountant to appear before the authority and prepare the compounding application in triplicate application to be accompanied with the affidavit verifying the application, memorandum of appearance or power of attorney, copy of the notice from the ROC if any, and other necessary documents. File E-Form GNL1 attaching the application along with the prescribed fee with the ROC. Check NCLT rules 2016 for prescribed fee, that is 1,000. Form GNL1 can be used for compounding of maximum 8 person, excluding the company. If number of person is greater than 8, then additional details can be provided in optional attachment. Further, following attachment are also required to submit with E-Form GNL1, that is joint application of the company and official default is allowed, and delivered sufficient number of the hard copy of the compounding application to registrar of companies. Based on the amount of the fine, ROC forwards the application to the NCLT or the regional director with the risk comment and personal hearing fixed before the NCLT or regional director. Payment of the fees for compounding within the prescribed time period mentioned, and compounding of fines shall not, that is noted, that compounding fines shall not exceed the maximum fine imposed for the offense so compounded under the relevant provision, and passing of the order by the NCLT or regional director, and intimation of order of the NCLT or regional director to registrar of company within 7 days of the receipt of the order in Form INC 28. Let's see the contents of the compounding application. And the general details of the company: name, register office, address, date of incorporation, nature of the business, main object of the company, facts of the case, nature of the offense, and period of the default, relevant section which has been violated, fine prescribed in section for violation, and details as to how the default has been made good, indicating the date on which the default has been made good wherever applicable, and prayer for compounding. That is content. Order of the competent authority. Once the prescribed amount is received by the competent authority would spell out that the applicant had paid the aggregate compounding amount. The order so passed end with the words, the offense is therefore compounded now. The said order would be signed, stamped, and sealed. A copy of the same is sent to the registrar of the company. After the offense is compounded, it amount to acquittal and not conviction. Compounding before or after institution of prosecution. Compounding application can be filed either before or after initiation of prosecution. An intimation shall be given by the company to the registrar within 7 days from the date on which the offense is so compounded, whether compounding is initiated before or after the institution of any prosecution. Where the compounding before or after institution of prosecution, where the compounding of any offense is made after the institution of any prosecution, in that case, such compounding shall be brought by the ROC in writing to the notice of the court in which the prosecution is pending, and on such notice of the compounding of the offense being given, the company or its official in relation to whom the offence is so compounded shall be discharged. No prosecution shall be instituted in relation to such offence either by the registrar or by any shareholder of the company or by any person authorized by the central government against the offender in relation to whom the offence is so compounded. As per subsection 5 of section 441 says that in case of the failure to comply with the compounding order, in that case, officer or other employee of the company who fails to comply with the order made by the tribunal or regional director or authorized officer under by the central government under section 4, the maximum amount of the fine for the offence proposed to be compounded under this section shall be twice the amount provided in the corresponding section. Earlier, this section is the there is a sentence imprisonment with a maximum term of the 6 months or fine is not more than 1 lakh. But now this section changed and says that the maximum amount of the fine for the offence proposed to be compounded under this section shall be twice the amount provided in the corresponding section. In which punishment for such offences provided, this is twice the amount provided in the corresponding section. That is the maximum amount of the fine in case of the failure to comply with the compounding order. That is the unique feature in Companies Act. Now see what are the difference between adjudication and compounding of the offences. Section 454 of the Companies Act says adjudication of the penalty and read with the rules adjudication of the penalty rules 2019, and section 441 of the Companies Act says for the compounding. For adjudication, the central government may appoint any officer not below the rank of the registrar as the adjudicating officer for adjudicating penalty in their respective jurisdiction. And for the compounding, competent authority are the National Company Law Tribunal or regional director based on the threshold limit of fine prescribed as the case may be. This is the for the regional director, that is amount not more than 25 lakh. No. As per subsection 3 for section 454, adjudicating officer can impose penalty on non-compliance of default under the Companies Act and direct such company or officer for the default on any other person as the case may be to rectify the default wherever he considered fit. While section 441 says that the company or any officer having committed an offence may apply for compounding voluntary. For adjudication, adjudication officer issues so-called notice to the company or officer in default. Opportunity of being heard is given and order is passed, and for the compounding, a company or officer in default on their own can apply for the compounding. Appeal against the adjudication order to be made to the regional director within 60 days from the date of receipt of the order. While for compounding, no appeal is allowed against the compounding order, and for adjudication, penalty are imposed by adjudicating authority without prosecution, and payment of sum of the money not exceeding the maximum fine prescribed in the relevant section under the compounding, and penalty are fixed amount under adjudication, while the compounding authority has the discretion to impose an amount lesser than the fine prescribed. Adjudication is the civil proceeding, and compounding helps to avoid criminal prosecution. That is the difference between the adjudication and compounding. In case of any query or doubts, you may write in the comments box or WhatsApp on my number 956008483. Thank you so much for watching this video.